This is Bloomberg Law with June Grasso from Bloomberg Radio.
I am Stormy Daniels, adult film star, mom, idiot who can't keep her mouth shut.
Stormy Daniels has told the story of a sexual encounter with Donald Trump in 2006 over and over and over again in the last 18 years, including in a documentary. But this week it was different because she told that story under oath on the witness stand in Trump's hush money trial, and she had to defend her account under tough pushback from a defense attorney who said she'd made it all up. The tawdry, embarrassing details were cringeworthy, causing the former president to curse audibly and shake his head. Joining me is Jessica Levinson, a professor at Loyola Law School and host of the Passing Judgment podcast. Big picture, did Stormy Daniels' testimony move the prosecution's case forward?
I think Stormy Daniels' testimony did actually move the prosecution's case forward because, well, I know there's been a lot of discussion about whether or not she went into too much detail and whether it's actually beyond the scope of the trial. When I take a step back and think about what the trial is about, part of the trial, it's about whether or not she got this hush money payment to try and make sure that the voters didn't hear her story. So hearing the details of her story, I think, does matter because I think what the prosecution is going to say is that was pretty hard. That was pretty tawdry. That really would have hurt President Trump's chances when he was candidate Trump. So now you understand why he made this payment to her. It was because he didn't want the voters to hear that right after the Access Hollywood tape, right before voting.
Technically, the prosecution could have presented its case without her testimony, right?
Absolutely. You could have had a prosecutor that decides we don't want Stormy Daniels. She was, I think, in some ways one of the riskier witnesses because you don't know exactly what she's going to say. It's not like somebody who's testifying to bank records and transfers and emails. Having said that, if you think about the case without Stormy Daniels, it has a lot of consequences, but not a lot of causes. And so Stormy Daniels' story about her alleged affair with the former president and the details of that and why she felt it was pressing to get that payment before the election, I think all sets into motion the story that we ended up hearing about and continue to hear about from the prosecution. I mean, this is the seed that started this whole chain of events.
Did the salacious and tawdry details dirty up Trump, you think, in the jury's eyes?
So this jury, I think, has certainly already heard a lot about Trump in the sense that he was our former president. We've all heard a lot of accusations about him. But I think that her testimony did dirty up Trump, so to speak, in part because she's bringing you into this very intimate encounter and it doesn't paint Trump in a good picture. It makes it sound like there was maybe something on the edge of non-consensual about this particular interaction. And she describes blacking out. And while she said, she wasn't drunk and she wasn't drugged, it doesn't sound like the type of encounter where she really wanted to be with the former president, who was then just a private citizen. So I think it was emotionally impactful for the jury. Does that go to any specific question in this case? Maybe not.
Trump's lawyer Todd Blanche asked for a mistrial twice, saying the judge had allowed Daniels to give far too many intimate details for a case involving business records. The judge agreed that Daniels shouldn't have been asked about some of these things, but said the defense hadn't objected to these questions when they were asked, which is true. The defense didn't object to a lot of these details that I now say are tawdry.
That's right. I think the judge, in saying that he would not grant the mistrial, really did put some blame on the defense, both before the testimony happened and while it happened. So before it happened, what I heard the judge saying in part was that the defense had focused part of their energy on whether or not there was an alleged affair between Trump and Daniels. And so the only person other than Trump who can really testify to that is Daniels. So in part, I hear the judge saying we should really understand that the defense is the one who almost necessitated putting her on the stand, that it's an invitation to have her testify and testify in some detail about having sex with Trump. The other thing is that the defense did not vigorously object at the time at all while she was testifying. So for some of the allegations here, the allegations that there should have been a mistrial, that it was too prejudicial, it was more prejudicial than probative, I really heard the judge saying, this isn't on me, and he'll try and do the best that he can do in terms of cleaning this up in jury instructions, and that the defense has a lot of blame for what happened.
The cross-examination was long and drawn out, and the defense attorney, who's a very experienced attorney, grilled Daniels over what I'd call small inconsistencies in the accounts that she's given of this over the last 18 years, like details like whether they actually ate dinner together, whether Trump's security man was standing outside the suite. Does impeaching on those little details help impact her credibility?
So I don't know. I think the prosecution still has a good theory of the case in terms of explaining why Daniels really doesn't have a motivation to lie at this point. And little inconsistencies, I think, are things that the jury would understand, particularly when you've told a story over and over again over a course of years, that there are certain things with respect to memory that might change. But the overall picture, I think the details of the story that Stormy Daniels has told over these years, the big details are all the same. I expect the prosecution will emphasize that. And I think what the defense was trying to do in part is, you made this up, the details change. Part of what the defense is arguing is you made this up because you just hated Trump. You made this up because that's part of what you do. You make up stories about people having sex, and, you've written adult films and directed adult films. But ultimately, it's up to the jury to determine if any of that really undermines the bulk of her testimony here.
Trump has reportedly been closing his eyes during some of the testimony. And during Stormy Daniels' testimony, the judge said Trump was cursing audibly. And in a sidebar, he said, I understand that your client is upset at this point, but he's cursing audibly and he's shaking his head visually, and that's contemptuous. The jury's watching Trump closely, as they watch every defendant. Do you think this kind of behavior has an impact on them?
I think everything affects the jury, and that's why, as a jury consultant, you would tell a defendant to dress a certain way, to act a certain way, to sit with their posture in a certain way, to, look straight ahead, take notes diligently, whatever it is that the attorneys or the jury consultant think are useful. But it just drains common sense to think that the jury isn't intently watching, particularly this defendant. And, to the extent that it looks like he can't control himself in the courtroom or he's otherwise behaving badly, in the jury's mind, I think they just can't forget that. Now, will that mean that they absolutely convict him? No, they still have to look at the facts that are separate and apart from Trump shaking his head and Trump swearing audibly under his breath. But all of this paints a picture for the jury, and they are humans, and they will remember how he behaved.
If Trump had a problem with Stormy Daniels, then get ready for Monday when Michael Cohen is expected to take the witness stand. What do you think about the way the prosecution has tried to prepare the jury for Cohen, where they've placed him in the trial and how they've sort of built up to him in different ways?
So I think the prosecution has done a good job of putting Cohen not right in the beginning and not right at the end, but where we've already heard a lot of testimony that will overlap with the story that Cohen is going to tell. And that's what's key for the prosecution, I think, which is to back every piece of evidence or testimony up as much as possible in a way that's almost duplicative, so that the jury could say, we're not sure that we really believe everything that Stormy Daniels said, but that there's enough of what she said that overlaps with other documents or other testimony that you can still link every piece in the chain to a conviction. And I think that's part of what we saw with respect to some of the more mundane testimony over the last few days about bank transfers and about the logistics of the hush money payment, where once you have Michael Cohen, I think what you really want is for the jury to almost anticipate much of what he's going to say. So that it doesn't sound surprising. It sounds like so much of the case that they've already put on is just leading up to this moment, and it makes sense for the jury intuitively.
Michael Cohen comes with so much baggage. Probably the defense is salivating at the prospect of cross-examining him. Does the jury have to believe Cohen in order to convict Trump, or does the prosecution have enough other evidence?
The jury has to believe some of what Michael Cohen is going to testify to. If they think that they can't believe Michael Cohen, but that there's other testimony or evidence that can bring them there, then that's okay. So, for instance, the jury, of course, step one is that these business records were, in fact, falsified. Step two is that they were falsified for a specific purpose, because Trump had the intent to commit or conceal another crime. And that other crime, I think, will either fall within the state or federal election law bucket or the tax fraud bucket. And so is it important for the jury to hear Michael Cohen and see him as a consistent part of the overall narrative that the prosecution is putting forward? I think it is. But again, if the jury can get to a conviction by looking at evidence separate from Michael Cohen, then that's okay. The prosecution knows who they have on the stand. They know he has tons of baggage. They know he has credibility issues, and they're going to try and do everything they can to make sure that the jury could convict without believing everything he's saying. Now, the other thing is you can find Michael Cohen to be a liar, but still think he's not lying under oath about these particular statements and circumstances.
We'll see if there are any fireworks in the courtroom on Monday. Thanks, Jessica. That's Professor Jessica Levinson of Loyola Law School, host of the Passing Judgment podcast. Coming up, TikTok sues the government. I'm June Grasso, and you're listening to Bloomberg.
Hi, everyone. It's Show here. As you may have heard, Congress passed a bill that the president signed into law that is designed to ban TikTok in the United States. That will take TikTok away from you and 170 million Americans.
TikTok CEO Shou Chew wasted no time in announcing that the company was going to fight in the courts to challenge a new law banning the popular app unless it's sold to an approved buyer.
Rest assured, we aren't going anywhere. We are confident, and we will keep fighting for your rights in the courts. The facts and the Constitution are on our side, and we expect to prevail again.
Again, because TikTok has indeed been successful at blocking attempts to ban the app before. But this new legal battle, which will pit free speech rights against national security interests, will be protracted and will likely end up at the Supreme Court. Joining me is Professor Eric Goldman, co-director of the High-Tech Law Institute at Santa Clara University School of Law. So TikTok, in suing, said, for the first time in history, Congress has enacted a law that subjects a single name speech platform to a permanent national ban. That's true, isn't it? This is unprecedented.
To my knowledge, it is. And it's really important for your listeners to understand that the legislation specifically names TikTok as a company and says this company cannot exist in its current format. And that's a pretty rare thing for a legislature to do.
Tell us about the complaint, the main reasons why TikTok says this is unconstitutional.
TikTok claims that the divestiture requirement at peril of being banned violates the Constitution, violates its First Amendment rights, is a unconstitutional bill of attainder, and it violates its equal protection rights. But the real payload is about the First Amendment. That's where everyone expects the action to be, that Congress is shutting down TikTok's speech.
As far as Congress shutting down TikTok speech, which seems pretty obvious, what are the defenses that the government can use?
The primary rebuttal will be that Congress acted based on national security concerns, that there are serious concerns about the ways in which TikTok operates that jeopardize national interests here in the United States. The problem with that argument is that we as the public haven't seen that data. To the extent that the data has been made available to Congress, it was done so in large part under seal, which means that Congress has seen information that the public hasn't. it's possible that we would agree that the evidence is significant and troubling. It's also possible that it's completely fictional. So we don't know how to evaluate this national security justification for the ban, in part because we don't have the evidence that Congress has been relying upon.
That's something that the complaint alleges. The government has yet to provide evidence of the Chinese government misusing TikTok. And they also say that the concern is just about a hypothetical possibility that TikTok could be misused in the future. I mean, has there been any evidence at all in the public that TikTok has been misused or that the Chinese government is using it?
There have been some whistleblower-type complaints that have provided some evidence suggesting that. Those complaints have been subject to their own critical scrutiny, so a little hard to know how reliable they are. But I think that it's important to reinforce the hypothetical nature of this, that the evidence showing that the Chinese government is actually undermining our national security using TikTok is vanishingly thin, if not non-existent. And so it's uncomfortable and perhaps impermissible under the First Amendment for Congress to ban an app on the potential that it might cause some future harm. If that's the grounds for banning speech, then of course legislators can always manufacture those types of hypothetical concerns.
So if this goes to trial, would a court, or even before trial, would a court ask the government to provide evidence that their concerns are real and not just speculation?
Yeah, there will be no doubt that in order for the government to prevail, they're going to have to show some of the evidence that was shown to Congress, and they'll likely do that under seal. And I believe, in fact, that's why this case is being litigated in the particular venue it's being litigated in, because I think that court regularly deals with national security concerns, so they may have the clearances necessary in order for the government to even share the evidence.
The D.C. Circuit.
Correct. That's an unusual thing, as you know. Normally, litigation starts at a district court with a single judge, but instead, this is going to an appellate court, which is likely to have multiple judges on the panel, and that's a weird place for a case like this to start, because the appellate court's not in the business normally of doing evidence gathering and review, and they're going to have to do that in this case.
Content-based restrictions have to meet a higher level of scrutiny. So will the government have to explain why it didn't pursue less speech-restrictive alternatives to address its concerns?
One of the ways that the government can justify the interventions it made, this divest or ban, is by saying that there were no better other options that would have preserved speech and still accomplished the government's goals. So we used the phraseology, were there less restrictive alternatives to the government? If so, then the method that they chose impacted speech too greatly. There was a way of doing it without impacting speech quite as much, and the Constitution would require that lesser alternative.
The complaint argues that a sale from ByteDance isn't possible and that the law would force a shutdown. Is that because of the Chinese government's restrictions on the sale of certain technologies like algorithms?
The complaint makes a number of arguments about why it would be impossible to divest. There are some concerns about transferring the algorithm, and there may be limit from the Chinese government on the transference of the algorithm. And also, the complaint describes how the overall platform has this massive code base that can't easily be carved off or segregated to a new buyer that the buyer could then just step in and start running, that it needs a lot of attention from developers who understand the code in order to keep it running and to keep improving on it. And so there are arguments that it would take a long time for a buyer to get up to speed sufficient enough to be able to take on the code base. And so the code base is a practical limitation on the sale, in addition to whatever technical or legal restrictions there are.
Stephen Mnuchin, the former U.S. Treasury Secretary, told Bloomberg that he's still interested in buying TikTok's U.S. operations.
I've actually spoken to a lot of tech companies on working about rebuilding this. I do believe the algorithms could be rebuilt. So my plan, if we were to purchase it, would be to rebuild the technology under U.S. leadership.
I mean, is that doable to replicate their algorithm?
I guess. In theory, it's possible that U.S. ingenuity could, catch up to and maybe even surpass the existing technology. The reality is that the U.S. competitors to TikTok have not been able to crack that nut, despite the fact that they are extremely well-financed and highly motivated. Turns out that TikTok's secret sauce has worked really, really well and isn't easily replicated. So any buyer who thinks that they can step in and with a snap of a finger keep doing what TikTok is doing is not reading the lessons from the existing competitors.
And is that secret sauce the algorithm's ability to learn about your interests and deliver more items like that to you in a sort of uncanny way?
I think that's the main secret sauce. I'm sure there are others, but it's the For You options on TikTok where they're able to deliver videos that are customized for each user that the users really respond to and that it actually speaks to them. And it turns out that's a really hard thing to do. Lots and lots of people have tried that over the years, and TikTok has found a magic to being able to do that for its users.
TikTok also argues that a ban would devastate 7 million businesses and shutter a platform that contributes $24 billion annually to the U.S. economy. Do you think those figures are accurate?
They're obviously self-interested calculations, so I don't know if they're right. But they don't have to be right to still be helpful. The bottom line is that there's a lot of economic activity taking place here in the United States that's being driven by TikTok, and in theory, Congress has said we want all of that to shut down. Now, some of them might migrate to other services, so it's not like it would be completely lost. But in a time when we're concerned about employment and we're concerned about the economy, the idea that we would take a major step back is a huge opportunity cost. And it really makes me wonder if the people who voted for the ban really understood who they might be benefiting and who they might be hurting. Chances are that people who voted for the ban are going to be hurting their own constituents.
Eric, where does it fit in that TikTok complains that Congress ignored its work to protect U.S. data from foreign government influence?
TikTok has undertaken extensive efforts to try to please the U.S. government, and they were negotiating a very lengthy document that would allow the government to have oversight into the ability of the Chinese government to influence TikTok's operation and to base all the content here in the United States. TikTok has said that it's going to implement a number of those pieces irrespective of the law and whatever the court holdings are. But the bottom line is TikTok is saying that they're comfortable with having the government monitor their behavior and oversee their behavior. They just don't want to be regulated in this other way. And it's weird for me, as someone who's interested in the free speech rights of TikTok and its users, for TikTok to say it's not like we are opposed to regulation, just do it in a way that we can live with, as opposed to saying there really should be no reason why the government gets this oversight at all. The First Amendment prohibits it. So it's really an interesting positioning by TikTok.
The deadline for the sale is January 19th. Do you think the D.C. court will speed up the proceedings? And even if it does, can this matter be resolved by then?
I think one of the reasons why the Congress specified that the challenges law would go through this D.C. Circuit review was to accelerate the answers, to try and speed up getting a resolution to whether or not the ban was permissible. So there's no guarantee that the D.C. Circuit will respond that fast, but I'm sure they get the point. They know the deadline, and I would expect them to do everything they could to try and get an answer before then.
But this might end up at the Supreme Court.
Seems inevitable that it will end up at the Supreme Court. But if we get the initial court ruling in favor of TikTok, there will be a staying of the law until there's appellate review. And even if the government wins, there might still be a staying of the law where the D.C. Circuit requests to preserve the status quo until the Supreme Court can weigh in. But there's no question that this ban, whichever way it's ruled on, is going to go to the Supreme Court. Now, they have the discretion whether or not to take it. They might not take the case, but it seems likely that this ban is going to end up at the Supreme Court and get a ruling on it.
From our conversation, it sounds like you think TikTok has the advantage in this lawsuit over the government.
This is not a new question. This question has been litigated several times in the last few years, and the courts have universally held in favor of TikTok. So it's possible that this ban is better than all the other ones have been challenged, but more likely the same problems that doomed those other bans are going to also doom this one as well. So, yeah, if I were a betting man, I would be putting my money on TikTok, not on the government.
We'll see if the government's odds improve when it files its answer. Thanks, Eric. That's Professor Eric Goldman of Santa Clara University Law School. Coming up, why the Supreme Court's record on unanimous opinions is about to evaporate. I'm June Grasso, and you're listening to Bloomberg. The Supreme Court has issued 20 opinions in argued cases so far this term, and 15 of them have been unanimous. That may seem unusual for a court that, with its super-conservative majority, often splits down ideological lines 6-3 in major cases. The unanimity is something many of the justices like to emphasize in public appearances. Here's Justice Amy Coney Barrett this past February.
You hear so much about our deeply divided court or the 6-3 court, but when you looked at the docket from last year, I think that might have been true in 5 cases or so. I mean, the vast number of cases are unanimous or almost unanimous.
But those 6-3 decisions are usually in cases involving divisive issues. Last term, that split was seen in cases on affirmative action, student loan forgiveness, and gay rights. So in the next 7 weeks, as decisions are handed down in controversial cases involving abortion, guns, racial gerrymandering, presidential immunity, and more, you can expect that unanimity to evaporate. In fact, it's already starting. The court issued its first 6-3 decision of the term on Thursday in a case you may have heard little about. Joining me is John Elwood, head of the appellate and Supreme Court practice at Arnold & Porter. He's argued before the justices many times. For those who are not familiar, will you explain the process the justices go through in making these decisions once they've heard oral arguments?
Sure. Well, the Supreme Court hears argument for basically 2 weeks every month between October and April. And at the end of, I think, each week of argument, they vote on, which position everyone's going to take on every case. And I believe that at the end of the whole sitting, there's a kind of a final tally where the person who is presiding, that is the senior-most justice in the majority, assigns opinions to all of the justices in a way that tries to give them kind of an equal share of cases, an equal number of authorships.
20 opinions in argued cases this term. 15 have been unanimous. I know the Chief Justice and Justice Barrett have talked about how the court is unanimous in a majority of cases. But tell us about the kinds of cases they're unanimous on.
Well, most of the cases that have been decided so far are not the kind of red letter, big ticket to mixed metaphors cases for the term. They're more generally the duller cases. There are a few cases that are more noteworthy, which were nonetheless unanimous, which were likely unanimous because they were so narrow. Like, for example, there were the social media blocking cases, Linky versus Frieden, O'Connor, Ratcliffe versus Garner, which involved a fairly big-ticket issue about whether when public officials block people on social media, that is essentially state action that is regulated by the First Amendment. And that was a case that really the justices seemed to have some trouble grappling with an argument, but they decided very little of it. They decided a fairly narrow rule and left most of the application for remand. And so I think that would have been a very easy case to not be unanimous if they had decided it any more broadly than they did.
And Chief Justice John Roberts has talked about the goal of achieving a unanimous opinion by narrowing the issues, as you say.
I still think it's an important objective. One, because I think judicial decisions should be narrower rather than broader. And the way to do that is to try to get as many people on board as you can. That, if you're going to reach a broad decision that's going to cover all sorts of different factual scenarios, a lot of people are going to say, well, whoa, I'm not quite sure I agree with that. And then they might write something narrower. But if you keep it narrow, that it only decides what's absolutely necessary to be decided, usually you can get more people to agree with that.
So are they trying to present a picture of this court that's in agreement and unanimous by narrowing the issues or choosing cases that don't involve divisive issues?
Well, to begin with, one of the things I like to emphasize is that when you're dealing with such small numbers, it doesn't take much for things to seem like outliers. When you're dealing with just like 18 cases, it only takes something like 4 extra cases to go from an ordinary term to a really unusual high water mark of unanimity. And so this is something that I always try to emphasize. When you're dealing with the Supreme Court, the numbers are so small that it doesn't take much for things to look like you have some real outlier term or real weird trend. But with that, I do think that the Roberts Court does try to emphasize unanimity. Also, there may be a different dynamic in that, they're trying to get cases out because they are relatively behind in getting opinions out. And so they may just, be writing opinions narrowly so they can clear those cases out, get them out so they can focus on the remaining cases. So there are a number of reasons why they might be doing it this way. I do think that they try to be unanimous whenever they can. It's kind of part of the ethos of the Roberts Court. John Roberts cares about it, and I think he tries to jawbone other people into feeling the same way. It may be that they're taking relatively few cases. There are a very low number of grants this term, and it may be that they are, picking out cases that they feel there's a fair amount of unanimity in. And it may be that they're, kind of clearing the way for more contentious issues which have yet to be decided.
Every year, the cases that we're waiting for involving hot-button issues come down at the end of June, sometimes the last 2 days of June. Is there a reason for that, or is it just dropping the hot potato cases that are going to cause controversy last, and then you're on vacation?
I think a lot is just explained by the practicality of it, which is that dissenting opinions take more time. And sometimes in the most contentious cases, there's back and forth between the dissent and the majority opinion. And when people are fine-tuning opinions, in draft after draft after draft, it can go kind of down to the wire. So I think much of it is explained simply by the practicality of, more opinions, more drafts take more time.
And will you explain the process of circulating the opinions so all the justices see what others have written and can respond to it?
That's right. A majority opinions circulate, dissenting opinions then circulate, and each subsequent draft is then circulated to the entire group. And then, justices who are joining opinions may ask for changes. Justices who are joining dissents may ask for changes. Authors of both majority opinions and authors of dissent may tweak their opinions to respond to the opinions on the other side. And each of those opinions will be circulated to the whole group with a red line so everyone knows what's new and what's been changed since the last draft.
I guess that does show why it takes so long. Now, as far as the oral arguments go, and everyone says you can't tell what the decision will be from the oral arguments, but can you sort of figure out the broad strokes of the decision from the oral arguments? Have you ever been totally surprised by a decision like, wow, I never expected that?
There have been some that surprised me. There was a case many years ago when oral argument was still in a pretty rigidly 1-hour format where there was actually kind of a reversal of position. The position that Justice Stevens seemed to be advocating wound up being taken up by Justice Scalia and vice versa. But I think especially under the new format, which essentially goes on as long as the justices have questions, I think oral argument is a much better predictor of where people are going to come out in the end. There are fewer surprises, I think, under this sort of format because all of the issues are thoroughly ventilated.
The court, it's been said a million times, but it's at its lowest approval rating since they've been taking those polls. Do you think that that matters to the justices or not? They're there for life, so...
Yeah, I don't think that they're unmindful of it, but I think that they kind of do the same thing year in and year out. They go in and they decide the cases, the way they feel that they should be decided. They may try to be more unanimous in a particular case or decide an issue more narrowly. And I do think that they're generally kind of an incremental and minimalist court in the sense that I think that many times they try to decide the least that they can decide. So, well, I don't think that they're unmindful of it. They read the newspapers. I don't think that they let it shape their behavior. I think that I'm kind of one of those Pollyanna-ish people who think that they really try to just do justice or they try to follow the law in every case.
You were talking about the oral arguments. As someone who's argued, do the lawyers like the arguments that often do go on for hours? I actually had a conversation with several other kind of repeat players the other day on this.
And I think generally one thing we like about it is that it really does allow everybody to be kind of heard fully. And I think that generally is a favorable thing. The downside is that it makes it harder to argue more cases, that you can essentially fully ventilate one controversial case per day. But if you have a second argument, it's going to get much more summary treatment. And, that makes it kind of more difficult for the court to hear more cases.
And they've been cutting down on the number of cases that they take each year.
And it's kind of at low ebb right now. It's kind of more in the 60-case range. And I don't know if they're related or not. Since they don't explain what they're doing, I don't know if they're related. Yeah. But one consequence of the longer oral argument format is that it makes it harder to hear two cases.
It would be nice if we had a little more transparency from the justices. Thanks so much for your insights on the court. That's John Elwood of Arnold & Porter. The Supreme Court handed down just 2 decisions this week, and neither was unanimous. Indeed, the justices split 6-3, with the conservatives in the majority and the liberals in the minority in one of those cases. The court ruled that authorities do not have to provide a quick hearing when they seize cars and other property used in drug crimes, even when the property belongs to so-called innocent owners, rejecting the claims of 2 Alabama women who had to wait more than a year for their cars to be returned. It may be the first 6-3 decision of the term, but it certainly won't be the last. In other legal news, the dramatic 2021 collapse of Archegos Capital Management will be replayed in a criminal trial over the next 2 months as prosecutors try to convict founder Bill Huang for market manipulation, racketeering, and fraud. In announcing the charges a year ago, the U.S. Attorney for the Southern District of New York, Damian Williams, called it a market manipulation scheme that nearly jeopardized our financial system.
This scheme was historic in scope. We allege that the defendants and their co-conspirators lied to banks to obtain billions of dollars that they then used to inflate the stock price of a number of publicly traded companies. The lies fed the inflation, and the inflation fed more lies. Round and round it went.
A jury was selected this week, and opening statements will begin on Monday. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.